Today is a 261st Friday group meeting. The topic is Bharatiya, Nagarik, Suraksha, Sanhita, recent judicial interpretation. The speaker is Mr. Raghavendra Seetharam Srivatsa, Sr.Advocate. He recently designated the Supreme Court. We felicitated him also. He is our regular member. So finally, 11th hour I catched actually. Believe it or not. Supposed to be another. Thank you very much. Now I request Rahul Sharma will say a few words about today's speaker. Rahul, please continue.
Good afternoon, everyone. Seshu sir has given me this privilege of introducing our speaker, Senior Advocate Raghavendra Seetharam Srivatsa, and I am deeply grateful for this honor. Senior Advocate Raghavendra Seetharam Srivatsa hails from Chikaballapura in Karnataka. He has practiced in trial courts in Bangalore and in the High Court of Karnataka before moving to Delhi. In Delhi, he has practiced mainly in the Supreme Court, attending to appellate work from different high courts. He also appears in high courts and tribunals. Senior Advocate Srivatsa qualified as an AOR of the Supreme Court in 2006 and did a considerable amount of work for the Supreme Court Legal Services Committee. Sir has represented various public institutions like the High Court of Karnataka, Hampi World Heritage Area Management Authority, Uttar Pradesh Vidhan Sabha, King George Medical College Lucknow, Coal India Limited, Uttar Pradesh Industrial Development Corporation, Bangalore Metro Rail Corporation Limited. Sir has also co-authored the chapter on online contracts in the book titled Legal Dimensions of Cyberthreat, published by the Indian Law Institute, New Delhi. He has also delivered many lectures on various topics of law. He has been a resource person in the training program for judges, senior police officers under the aegis of institutions like Allahabad High Court, Police Department of Chhattisgarh in collaboration with Hidayatullah National Law University, Raipur, Maharashtra Judicial Academy, etc. He was designated as a senior advocate by the Honorable Supreme Court of India on 19 January 2024. Thank you.
Thank you, Rahul. Nicely explained.
Respected elders, respected Sheshu sir, Rahul, thank you for the generous introduction. Namaskar to all of you. It's customary to say good afternoon or good evening. I would prefer Bharatiya way because today we are going to discuss the ramifications of Bharatiya Nagarika Suraksha Sanhita. We've moved away from the Indian Penal Code and the Indian Evidence Act and the Code of Criminal Procedure. Today we are in the era of Bharatiya Sanhita. So Sheshu sir has always been very kind. He needs no introduction on that count. I'm sure all of you will endorse my view. He was kind enough to say that he caught me at the 11th hour. And I must tell you that he caught me at the 11th hour as the 12th man. You know, in a cricket team, we have a 12th man. So, today, I have big shoes to fill. As the 12th man, being a substitute for a doyen of the bar, particularly doyen of criminal law, Mr. Hariharan, who is the president of the Delhi High Court Bar Association, because of very important preoccupation, he could not make it. So, somebody who is as eminent as Mr. Hariharan in the field of criminal law. So yesterday when we were discussing the topic for today's discussion, we discussed various aspects, but we zeroed in on the recent experiences, the early experiences, if we should say that, on Bharatiya Nagarika Suraksha Sanhita. Because this law, as we know, the trinity of the criminal laws, the Penal Code, the Code of Criminal Procedure and the Evidence Act, all three of them were enforced only with effect from 1st of July 2024. So we are just about a year after the coming into force of these three acts, and today we are discussing only the Bharatiya Nagarika Suraksha Sanhita, which replaced the earlier Code of Criminal Procedure. So, last year during the summer vacation, I had an occasion to speak to, if we can call it that, the trinity of criminal justice. My first series of lectures was to senior police officers in Chhattisgarh. The IPS officers had to be trained. That's a mandate of the Ministry of Home Affairs. So I spoke to them on Bharatiya Nagarik Suraksha Sanhita and the Bharatiya Adv. Lo and behold, my next assignment was to speak at the Judicial Academy attached to the Bombay High Court. So I was speaking to them about the Suraksha Sanhita and the Sakshi Adhiniyam to senior judicial officers in the state of Maharashtra. So two elements of the trinity are now complete. It so happened that just after 1st of July, I happened to be in Bangalore for a matter. I come from Bangalore, and the Bar Association there invited me to speak, and they made it very attractive for me. They wanted me to speak in Kannada. So I spoke to them in Kannada on this. So I, at that time, except the time when I spoke in Bangalore, my opening remark was that we are discussing these laws at a time when the lady of law is in labor, because the law is yet to be delivered, because it was yet to be given effect to, and the date of enforcement was specified as 1st of July. Now, today, just over a year after it has come into force, we are in a state of twilight, expecting a new dawn. And light has already started coming from various courts, including the Supreme Court, on many aspects of the Bharatiya Nagarika Suraksha Sanhita. So, Sheshu sir and I agreed that it would be apt to trace the judicial interpretation of some of these provisions which we are able to lay our hands on till today, because the law is still in its infancy. It is still in its nascent stage. The efficacy or the impact of a law will be known only when it endures the test of time and as it plays out in course of time in practical, realistic situations. So, when a law is made by the Parliament, in fact, I am given to understand, there is a concept of judicial impact assessment. When a law is drafted by the... So, judicial impact assessment is an exercise that the draftsmen also undertake with the objective of what is the load it is going to cause on the courts, because ultimately it is the courts that will take the burden of interpreting and enforcing the laws. So that is a niche area, and today, in the 1 year that the Suraksha Sanhita has been in place, we have certain views. There are grey areas which need to be sorted out, but we will have a look at some of those judgments. Now, before I take you to the judgments per se, I'd like to say this. Why did we need this new law? We've all had the benefit of 5 elaborate lectures on the new criminal laws by none other than Justice Nagamuthu, and who can be a better person. In fact, I realized when I was reading for today's lecture that Justice Nagamuthu has appeared in a writ petition which challenges Section 223 of the Bharatiya Nagarik Suraksha Sanhita, that is pending in the Supreme Court. Justice Suryakant has issued notice. Manargudi Bar Association has challenged that provision. We'll come to that as we discuss the provisions. So, why did we need a new law? And like they say, the life of the law has not been logic but experience. So, between last year and now, my experiences while interacting with police officers, with judicial officers, with members of the bar, I've learned so many things. A very significant thing that I learned, and which can be applied in the context of the Bharatiya Nagarik Suraksha Sanhita, is the motto of the Chhattisgarh police. See, I was speaking to IPS officers in Chhattisgarh. I was very, very impressed by the motto on their logo. It said Paritranaya Sadhuna. How meaningful. Police is meant for the protection of the innocent. Paritranaya Sadhuna. So if you take the entire shloka from the Bhagavad Gita, Paritranaya Sadhunam, Vinashaya Cha Dushkritam, Dharma Samsthapanarthaya, Sambhavami Yuge Yuge. Lord Krishna says, to protect the innocent and to eliminate the evil and to establish dharma, I will take incarnations yuge yuge, from time to time. So this Bharatiya Nagarika Suraksha Sanhita is the new incarnation of the earlier law, and it meets the demands of time, our experiences. And as we can see, I'm sure all of you must have already heard from Justice Nagamuthu when he analyzed the provisions. What I am saying now also finds a mention in some of the judgments. Some of the judgments of courts indicated certain principles, salutary principles, which may be taken note of by the Parliament. So they have been adopted while making the new law. So today we have the Bharatiya Nagarika Suraksha Sanhita. See how beautifully it is worded. It doesn't take much of an effort to decipher what Suraksha Sanhita. It is meant for Suraksha of the citizens of this country. So it is a code meant for the Suraksha, which means the protection and promotion of the interests. And being a procedural law, I say this with some responsibility because there was some debate at some point of time long ago whether the Code of Criminal Procedure is a procedural law or a substantive law. Now there is a recent judgment of the Supreme Court, the Constitution Bench, which takes the view, particularly in the context of Section 468 of the CRPC, dealing with limitation and all that. They say these are procedural laws and they should be looked at as handmaids of justice and not as the mistresses of justice. So therefore they have to be given a liberal and lenient interpretation. So if we start from there, we'll start with how in the last 1 year, between 1st July 2024 and now, the applicability of the Bharatiya Nagarika Suraksha Sanhita to cases which have come up before the court and which were pending before the court. The earliest judgment, as I have been able to find out, is one of the Punjab and Haryana High Court, where a criminal revision petition was pending. It was a belated petition. It was filed beyond the period of limitation, and an application under Section 5 of the Limitation Act had been filed. When the matter was taken up, it was argued that from the 1st of July 2024, as per Section 531 of the Bharatiya Nagarik Suraksha Sanhita, Code of Criminal Procedure has been repealed, and it is only the provisions of the Sanhita that will apply. The court dealt with that situation, and to the credit of the learned judge who dealt with the matter, and that was probably the earliest case in this country, he analyzed it beautifully, and one has to look at the facts of a particular case also, because we cannot divorce the facts from the proposition of law that has been laid, because ultimately we have to remind ourselves of Lord Halsbury's salient remark that a case is a proposition only for what it decides and not what we can logically infer from it. So therefore, in that case what had happened was, like I said, the revision petition was belated. It was pending before the court. An application was also pending. The question is whether because the provision for repeal says any application, petition or any other proceeding pending before a court on the date of enforcement of this act. Now, it was argued that what is pending before the court was only the application for condonation of delay and not the criminal petition as such. The learned judge interpreted it in such a way that you can't file an application in vacuum. It is filed only in a petition under section 401 of the earlier code. So it was decided that notwithstanding the repeal of CRPC with effect from 1st of July 2024, the proceedings that are pending before the court shall continue to be governed by the provisions of CRPC itself. There are, and we are not discussing the provisions of CRPC any differently from the provisions of the Sanhita. There are a few areas where there are certain departures which are taken note of by the Supreme Court and also by the High Courts, and those are significant. So we will discuss all of them when we take up one of these, all of these judgments one by one. So on the first aspect as to repeal of CRPC and the applicability of the new Sanhita to proceedings that are pending, that was the first judgment of the Punjab and Haryana High Court. And then on the same aspect, if we look at it now, please see how the seminal role that our Supreme Court has been playing in the protection and promotion of personal liberty. And see what is the jurisprudence that we are having these days. It's enriching jurisprudence. Notwithstanding the fact that 531, section 531 of the Sanhita says that if an FIR is lodged after 1st of July, then the provisions of Sanhita will apply. There are at least 2 cases where recently, in recent times, the Honorable Supreme Court has said that beneficial provisions should be given a retroactive effect. Now, the one that the court mentioned was section 349, what used to be, sorry, not 349, 479 of the Bharatiya Nagarik Suraksha Sanhita, where if an under trial prisoner has completed 1/3 of his sentence, then he should be given benefit and should be enlarged on bail. Now this was applied notwithstanding the fact that the FIR was lodged before the coming into force of the Act, and the court reasoned that this is in terms of an earlier provision in CRPC. There was an earlier 436A, if I am not mistaken, and being a beneficial legislation, the benefit should be given to the accused. And also, you must be aware that various non-adversarial public interest litigations are going on in the Supreme Court regarding declogging of prisons and dealing with inhuman punishments given to convicts and all that. So the court has said that if we apply section 479, in cases where the accused has completed 1/3 of his total sentence, he should be given the benefit of bail, that is in the interest of promotion of personal liberty and also in the interest of declogging the overcrowded prisons in this country. That is as far as the retroactivity or retrospectivity of the provisions of Bharatiya Nagarika Suraksha Sanhita are concerned. Now, there was a case that arose under the Prevention of Malinarum Act, PMLA, Kushal Kumar Agarwal versus Directorate of Enforcement, 2025, SEC Online Supreme Court 1221. Now this dealt with a situation where the complaint under PMLA was lodged after 1st of July 2024, and cognizance had been taken without issuing notice or without affording an opportunity to the accused, as is required under section 223 of the Sanhita. Now this is a new development which has been incorporated as part of the statutory mechanism. This requirement was not there under section 200 of the Code of Criminal Procedure. So, in Kushal Kumar Agarwal, the Supreme Court said if the FIR is lodged after 1/7/2024, then the mandatory provisions of 223 of issuing notice to the accused before taking cognizance has to be complied with. It is indispensable. Now, please look at it. There is a judgment of the Calcutta High Court, again on 223(1), where that was also a case that arose under PMLA. There it was argued that a complaint under the Prevention of Money Laundering Act is a complaint under a special law. It is not an offence under the earlier IPC or the new Bharatiya Nyaya Sanhita, BNS. And section 210 of the BNSS, Bharatiya Nagarik Suraksha Sanhita, is an exception to the rule in 223, and therefore when a complaint under a special law is filed, there is no requirement for the court to afford an opportunity to the accused before taking cognizance. That was the argument. That argument was rejected on the reasoning that the code, Sanhita is a code, has to be read as a whole. You can't read one provision in isolation. So when you read the code as a whole, 210 read with 223 makes it mandatory for the court to afford that opportunity. And the question further arose. Now there have been a number of judgments, a number of high courts have been seized of this question. Karnataka High Court has dealt with this question. The Punjab and Haryana High Court has dealt with this question. But I found this judgment of the Calcutta High Court to be very instructive. And of course, the Supreme Court has also upheld that position in Kushal Kumar Agarwal's case. Now, the Calcutta High Court says this provision of affording an opportunity to the accused before taking cognizance is a filter provision. See how beautifully the court has put it. It's a filter provision. It filters out unjustified, frivolous, vexatious and unsustainable criminal action. You can't subject a citizen to such frivolous or vexatious criminal proceedings. So, it is with a salutary purpose that the legislature has mandated the issuance of such notice and affording such opportunity to the accused. The further question that arose was, at what stage? Now that has also been settled. The courts have now settled that under 223(1), the statements of the complainant and witnesses, if any, have to be recorded. The magistrate has to satisfy himself. So only after that he has to issue a notice to the accused and then take cognizance of the offence. So that is the law as it stands today, and that's a very significant judicial interpretation that we have in the last 1 year. I started with a caveat. I must reiterate that caveat now, that this provision 223(1) is pending challenge in a writ petition filed by the Manargudi Bar Association. It's pending before the Honorable Supreme Court. This judgment of the Calcutta High Court, the title is Tutu Ghosh. I will share the judgments after I finish my presentation. So, 223 is one significant area which required, which makes a departure from the earlier code and requires the mandatory issuance of notice and the affording of an opportunity to the accused. Now, any law dealing with criminal procedure has to necessarily deal with, and it has to provide for, fair investigation, fair trial, and reasonable humane sentencing. These are components of a criminal trial, because the investigation also has to be fair. Now the jurisprudence on that aspect is growing. You're all aware that the Supreme Court Justice Lalit's judgment has taken a view, I think in Manoj, that in the case diary, if there is something that is beneficial to the accused, that has to be provided to the accused, and the accused can use it to his advantage. So, investigation has to be fair, trial has to be fair, and the trial has to be fair. That involves fair prosecution also. There is one provision in the Sanhita which is a little debatable. So far, we haven't had any ruling on that, because now this Sanhita makes provision for a directorate of prosecution, and that requires that a charge sheet prepared by the investigating officer has to be approved by the director of prosecution before it is laid before the court. Now I have my doubts on that, because ultimately director of prosecution means it is the state. Now investigating officer should have autonomy and complete independence. There should be no interference. In fact, the court will also not interfere or dictate the course of investigation. Anyway, let us wait. We will surely have some pronouncement on that. So, that is on the aspect of fair prosecution. Now, you look at the investigation part of it. In the course of investigation, an accused may be required to give his specimen signature, samples, blood samples, or other samples for purposes of DNA. Now, in Selvi, followed by later judgments, it is settled by the Supreme Court that forceful imposition of narco analysis is unconstitutional. It violates Article 20. That is as far as narco analysis is concerned. But courts did uphold the taking of specimen signatures and collection of other forms of evidence. Now in the Bharatiya Nagarika Suraksha Sanhita, an express provision has been made in 349 for the investigating officer to take voice samples, because today we are living in the age of cybercrime, cyber frauds, and more technology based crimes. So voice samples can be taken in the course of investigation. That is now built into the statute itself. We don't need a judicial interpretation of that. Whether it will offend the doctrine against self-incrimination under Article 20, we don't have to go that far. Of course, nobody has challenged this provision so far, but we take it that given our experience with the earlier state of the law, this provision should hold the field, and what I just said has been upheld by the Rajasthan High Court in a case called Badri Prasad Meena. Section 349 has been interpreted, and the court has said that the provision carefully balances investigative needs and the constitutional safeguard of the right against self-incrimination under Article 20, Clause 3. So, one provision dealing with investigation has also been interpreted. Now, we come to we are dealing with investigation, so let me deal with that. I think that will be quite pertinent in this context. The question of remand, police custody or judicial custody, the entitlement of the investigating officer to seek police custody. There has been some shift in the law from the earlier statutory provisions to what are contained in the Sanhita today. So 60 days and 90 days depending on the nature of offence and whether the police custody has to be sought within the first 40 days. Now that came up for interpretation in one case. The Karnataka High Court has dealt with it. Now we must be aware that this is 167 of Code of Criminal Procedure. In the new law it is section 187. There is a difference between 167 of CRPC and 187 of BNSS in the sense that for offences punishable more than 10 years, the period is slightly enlarged. The BNSS, the court was dealing with a question whether an order of the magistrate refusing police custody was sustainable in view of the new provisions. The state was in revision before the High Court and also the complainant. The court took the view that if the offence is punishable between 1 year and 10 years, the investigation must get completed in 60 days. Otherwise, it is 90 days. As to whether after the first 40 days the investigating officer can seek police custody, the court answered it taking note of judgments dealing with personal liberty vis-a-vis police custody. You are all aware of that series of judgments Justice K.M. Joseph's in recent times, that police custody should not be granted as a matter of course. The court has mandated that there has to be application of mind and reasons have to be recorded to give police custody. And that is for the reason that personal liberty of the accused is seriously hampered if custody is given as a matter of course. Permit a small digression at this stage. Justice Karpavinayagam is here. He is a doyen of criminal law. When he was a judge of the Madras High Court, I have dealt with any number of cases that were decided by him on criminal law. Common misunderstanding among us lawyers. We discussed it, in fact, with judges and lawyers in other states. And when an application for remand is moved before the magistrate, somehow there is a wrong understanding among lawyers and judges that an application for bail is not maintainable. Because I have seen this happen. I don't know, I don't appear much in criminal courts in Delhi, but I have seen this happen in my home state. The magistrates and trial judges frown upon lawyers that when there is an application for remand, how can you maintain an application for bail? Now this is exactly what Justice K.M. Joseph has said in that recent series of judgments, if you take note of, that it has nothing to bail is a matter of right. In fact, it is a fundamental right. Right? So, now coming back from the digression, in this case, interpreting the provisions of section 187 of the Bharatiya Nagarik Suraksha Sanhita, the court said the strict terms of the statute have to be applied, and once that prescribed period elapses, the police officer cannot seek custody. That is as far as section 187 of the Bharatiya Nagarika Suraksha Sanhita is concerned. We dealt with the aspect of repeal of CRPC by section 531 of the BNSS and the ramifications of such repeal. While interpreting the effect of repeal, I dealt with that case of Punjab and Haryana, that belated revision petition and all that. The Honorable Judge has also cited section 6 of the General Clauses Act. What is the effect of repeal and all that. But there is a very significant case that we should all take note of. See, we are sitting in Delhi, northern part of India. We are all aware that in Uttar Pradesh there was no provision for anticipatory bail. So people used to move 226 petitions and in that seek an interim relief of stay of arrest, protection from arrest and all that. Now, that was also interpreted by the court that you can't take away the right of anticipatory bail and all that. Now the question arose in this particular case, the name of the case is Sudhir versus State of Uttar Pradesh, 2025 SEC Online Allahabad 3434. Sudhir versus State of Uttar Pradesh. While dealing with repeal of the provisions of CRPC, now 438 of CRPC, the corresponding provision in Bharatiya Nagarik Suraksha Sanhita is 482. The argument of the state was that there was no provision for anticipatory bail as per the UP amendment. So therefore, that state of the law should continue. So, notwithstanding the enforcement of the Bharatiya Nagarik Suraksha Sanhita and section 482 thereof being in operation, state of Uttar Pradesh will still not have any provision for anticipatory bail. This argument was tested and was rejected on this reasoning. The reasoning is that while 438 had certain guidelines for the court, see, bail is a matter of discretion. So, there were certain provisions. But 482 enlarges the scope of discretion. So, there is a departure from the earlier law. The court said the primary difference in both of the provisions, apart from the prohibition indicated in section 438(6), is that the factors indicated for grant of anticipatory bail in 438(1) are absent in 482 of the Bharatiya Nagarika Suraksha Sanhita. So, and this is the significant finding. In the absence of any specific intention to continue the earlier provision, the UP amendment to anticipatory bail stands repealed by BNSS, which means the UP amendment also goes. So therefore, 482 of BNSS will have its full play and the provision for anticipatory bail holds the field. That is the significant finding. There is a statement of law that now that is as far as bail and anticipatory bail, police custody and all that. While still dealing with investigation, because the very process is initiated with the lodgement of an FIR 173. Now I will come to Justice Oak's judgment in Imran Pratap Gadi, because one will have to deal with it in some detail, because Justice Oak has taken note of the significant departure that BNSS makes from the provisions of 154 of CRPC, before we go there, I must mention the concept of zero FIR. Now that was introduced in 173 of BNSS. The concept is that irrespective of which place has jurisdiction, you can lodge an FIR. So that provision has been held to be in the interests of justice and to subserve the citizens as a whole. This has been considered by the Kerala High Court in a judgment called DBS Bank India Limited versus State of Kerala. Of course, 531 I have already dealt with. There is another, you can just make a note of this because this judgment of the Bombay High Court, it's called Chaugale and Company Private Limited versus State of Goa, 2024 SEC Online Bombay 2501. This judgment deals with the effect of repeal and whether we discussed in the context of Uttar Pradesh, we discussed the availability of the power to grant anticipatory bail. In Chaugale, the Bombay High Court dealt with the question whether under section 482 of the BNSS, the court has the power to grant interim bail. And the court held that if it was available as per judicial interpretation in the earlier regime, in view of the wider net of jurisdiction conferred under 482, it should be available. The court has the power to grant such interim orders. Now we have dealt with opportunity to accused under 223 and then the question of bail, anticipatory bail and humane sentencing and declogging the prisons, 1/3 of the sentence having been completed. There are two significant aspects that remain which require a slightly detailed analysis, and we'll have to look at the judgments of the courts in this regard. I will first deal with what is a significant departure made by the Sanhita in the context of sanction for prosecution. I will just draw your attention to that. As far as the Supreme Court is concerned, I could lay my hands on only one case, one judgment, where of course the Bharatiya Nagarik Suraksha Sanhita was not in question. That was a case that arose under the earlier law, but a passing reference was made, and Justice Dipankar Datta has dealt with that aspect. I will come to that a little later. But before we deal with that, the section is section 218 of the Bharatiya Nagarik Suraksha Sanhita. And what I want to deal with in particular is the aspect of deemed sanction. Section 218 of BNSS makes a provision that if the sanctioning authority does not give its sanction or respond within a prescribed period of time, then there is deemed sanction to prosecute and the court can accordingly proceed. I have my serious reservations on such a statutory provision, and I'll tell you why. And after I have submitted my proposition for your consideration, I will back it up by Justice Nagaratna's judgment, which dealt with an analogous situation but under the old law. sanction to prosecute is not an empty formality. Under 197, sanction to prosecute is a salutary requirement to ensure that officers of the government, public authorities, in the discharge of their public functions, are not exposed to frivolous and vexatious litigation, unjustified criminal prosecution, and therefore sanction has to be given by the appropriate authority. There are several aspects to this. Sanction should be given by the appropriate authority. If the authority is not proper, there goes sanction. Now, in the absence of sanction, it has been decided by any number of judgments of this court that sanction is a jurisdictional aspect, because the court cannot take cognizance without sanction. Now, if there is no sanction, there is no question. Then the question will arise, further question will arise, whether at all sanction is required. Now, let us assume a case where there is sanction. Cognizance is taken and the trial proceeds. It is open to the accused at the trial to question the validity of the sanction. With the permission of Justice Karpavya Nagam, sir, am I right? So, the prosecution has to prove not only the existence of a sanction to the adequate material by the sanctioning authority and the appropriateness of the authority which gave sanction. All these things have to be proved as a matter of fact at the trial. If the accused is able to demolish any one of these aspects, the sanction is not valid and the prosecution will not succeed. In this backdrop, please look at the provision of section 218 of Bharatiya Nagarik Suraksha Sanhita. What will happen if there is no sanction, whereas there is a requirement of sanction by the law? The law mandates that sanction, valid sanction, has to be given, but by a fiction, deeming fiction, you say that there is deemed sanction. You look at it from both points of view. Let us first look at it from the prosecution point of view. It is a win-win if you look at it that way, because the sanctioning authority will simply go into slumber, and after the lapse of that prescribed time, the prosecuting agency will say that there is now deemed sanction, so therefore take cognizance and proceed. If I were the defense counsel, I would argue this. There is a requirement of sanction. That is why you ask for sanction. Sanction has not been given for whatever reason. What is this concept of deemed sanction? Justice Nagaratna has frowned upon the very phraseology deemed sanction in that judgment. You look at it from the point of view of the defense. Like I said, sanction and valid sanction has to be proved as a matter of fact. If I were the defense counsel, I would simply say this, that there is no mind. So where is the question of application of mind? Because nobody has looked into the material. There is no consideration of material. So no question of application of mind at all. So if you put it in colloquial terms, na raha baas na bajegi basuri. So it's a cakewalk for the accused. So the legislature has, for some reason, introduced that provision. But we have to wait for the courts to interpret that particular, because according to me it is a very strange provision. Now, having given you a backdrop of how this deemed sanction plays out, we should look at the recent judgment of Justice Nagaratna in the case of Sunita Tuteja. Sunita Tuteja. I'll take another 10 minutes.
Yes, please, sir.
Sunita Tuteja was a case where admittedly sanction was required. And it turned out that sanction was sought also, but was not given. Now the magistrate took cognizance. The accused wanted quashment of proceedings. High Court refused. And before the Supreme Court, it was argued that since sanction has not been given within a particular, and mind you, this was a case that arose under section 197, under the old regime. The court was not dealing with BNSS at all. But there is something very significant that is recorded in Justice Nagaratna's judgment. I will tell you that, which has a direct nexus with BNSS today. The argument of the prosecution was that there is deemed sanction and that is good enough. The court took serious exception to the concept of deemed sanction, and the attempt of the prosecution there was to rely on two judgments of the Supreme Court which according to the prosecution had approved of the concept of deemed sanction. Vineet Narayan, of course under the Prevention of Corruption Act, there the position may be a slightly different. We are not dealing with that today. Vineet Narayan and Subramaniam Swamy's case. Please see the significant strides we are making in development of criminal jurisprudence. Justice Nagaratna took it head on, analyzed those two judgments, Vineet Narayan and Subramaniam Swamy, and said, you read the judgments as a whole, both those judgments. And the court says in Sunita Tuteja that the court never said in those two judgments that there is a concept of deemed sanction. The court said that it is unknown to law. Something as deemed sanction is unknown to law. While doing so, Justice G.Seshagiri's concurring opinion in Vineet Narayan, there Justice Singhvi, while agreeing with the other judges, recorded his reasons and made certain suggestions for the consideration of the lawmakers. That very tenable and very good cases which deserve a proper prosecution and punishment of the guilty will be actually defeated and the accused will go scot-free if the appropriate authority decides to go into slumber. And that happens for obvious reasons. So Justice Singhvi in his concurring opinion made certain suggestions to the Parliament that please consider if you can have a provision for a deemed sanction if the sanction is not granted within a particular frame of time. So what we have in section 218 of BNSS today probably has its roots in that concurring opinion of Justice Singhvi. But how it plays out in actual practice and how far it is valid and in tune with constitutional principles is something that only time can tell us, because that provision is yet to be tested by any court of law. So this Sunita Tuteja, while ending the judgment, Justice Nagaratna clearly records that as on today on the statute book we have no provision for deemed sanction. So therefore, we cannot agree with the prosecution that there can be deemed sanction. Of course, in the new act we have that provision, so we'll have to wait for a judicial interpretation of that. Now I come to the most significant aspect, which is section 173 of the Bharatiya Nagarik Suraksha Sanhita, which is the new avatar of section 154 of the Code of Criminal Procedure. Lodgement or registration of an FIR by the police. Imran Pratap Gadhi was a case that arose again from Uttar Pradesh. The complaint was simply this, that he recited some poem or something like that, and then whether it incited communal violence or it had the tendency to disturb harmony in the society. So he was charged under those relevant sections of the Bharatiya Nyaya Sanhita. Of course, that is a recent case. The complaint and FIR is after the advent of the new criminal laws. So he was charged under the relevant provisions of the Bharatiya Nyaya Sanhita, and he sought quashment of the proceedings. One of the arguments was that my right to free speech and expression is curtailed by the initiation of criminal prosecution. The High Court simply dismissed the quash petition on the reasoning that investigation is still at the nascent stage. So therefore the court should not interfere with the process of investigation. 582 I think is the new provision. 482 was the earlier provision, 582 of the new provision. The court should not interfere with the process of investigation, and on that reasoning it rejected the petition for quashment. When the matter reached Supreme Court, Justice Oak, look at the greatness of the man, towards the end of the judgment he writes one paragraph. This judgment is authored by Justice Oak with valuable contributions from Justice Ujjwal Bhaiya. Look at the greatness of the man. So, Justice Oak has analyzed the shift, significant shift that we have made from the provisions of 154 CRPC to 173 CRPC. If I can refresh your memory at 4 o'clock in the afternoon without a cup of tea, it's difficult, but I had mentioned to you that certain principles evolved by judgments of courts have found their way into the statute book. You remember Lalita Kumari, where there is no provision in 154 CRPC for a preliminary inquiry, but a judicially evolved principle in the interests of justice and to ensure that frivolous and vexatious prosecutions do not happen, clogging the system as a whole. The court said that in certain types of cases, guidelines were issued. The police has the power or discretion to conduct a preliminary inquiry and decide whether to lodge an FIR or not. That principle, with certain changes and a tweak here or there, has found its way into section 173(3) of the Bharatiya Nagarik Suraksha Sanhita. 173(1) deals with lodging of an FIR where a cognizable offence is made. Now that 173(3) is that significant provision where the statute expressly invests the police with the discretion to hold a preliminary inquiry and take a call whether to proceed to lodge an FIR and take up investigation or not. Now, in what circumstances and what are the guidelines dealing with such a discretion has been beautifully explained by Justice Oak in the case of Imran Pratap Gadhi. So, permit me to place, yes, I'll just give you the relevant paragraphs. You can just note section 23, para 23 of Imran Pratap Gadi, and the conclusions in that case are in para 42. And the court says subsection 3 of section 173 of the BNSS makes a significant departure from section 154 of CRPC. It provides that when information relating to the commission of a cognizable offence which is made punishable for 3 years or more but less than 7 years is received by an officer in charge of a police station with the prior permission of a superior officer as mentioned therein, the police officer is empowered to conduct a preliminary inquiry to ascertain whether there exists a prima facie case for proceeding in the matter. However, under section 154 of CRPC, as held in Lalita Kumari, only a limited preliminary inquiry is permissible to ascertain whether information received discloses a cognizable offence. Moreover, a preliminary inquiry can be made under the CRPC only if the information does not disclose the commission of a cognizable offence. In the category of cases covered by subsection 3 of 173, a police officer is empowered to make a preliminary inquiry to ascertain whether a prima facie case is made out for proceeding in the matter, even if the information received discloses commission of any cognizable offence. So that is a very, very significant ruling, and that will go a long way in the protection and promotion of personal liberty and ensuring that frivolous criminal prosecutions do not clog the system. With these respectful seniors and my learned colleagues, I end my talk for the day, and I thank you very much.
Thank you. Thank you very much. Thank you very much, Raghavendra. Such a way you enlightened us this new laws, new criminal laws, and judicial interpretation. Really, it's I never expected, honestly, and should appreciate that. Now I request, Geetanjali Sharma will give a vote of thanks.
Good afternoon all. I am delighted to offer the vote of thanks on behalf of the Friday group to Mr. Raghavendra Seetharam Srivatsa, Senior Advocate. Sir, extra thanks to you for being the very, very reliable 12th man and saving the day for the team. Sir, the topic for today was Bharatiya Nagarik Suraksha Sanhita, recent judicial interpretations. And you actually very graciously took us from the beginning, starting with Punjab and Haryana High Court, Kushagar Kumar Agrawal versus ED. Sir, you also referred to the case of Tutu Ghosh of Calcutta High Court, which dealt with 2231 of BNSS, while also underlying the fact that the very same provision is pending challenge before the Honorable Supreme Court. Sir, you also dealt with the very important case of Sudhir versus State of UP, which dealt with the provisions of anticipatory bill that it still holds the ground under the new code. Sir, you also referred to the grey area of the concept of deemed sanction under Sanhita Tuteja case. Very thank you, sir, for being gracious enough to find time at the last moment and delivering this lecture. Thank you to our beloved Judicial Rao sir for being the perseverant administrator and architect of the Friday group. So without you, these lectures are not going to happen. A very warm thank you to all the attendees for supporting us silently and actively by attending the lectures and motivating us to go on and on. Thank you, everyone.
Thank you very much, Geetanjali. Now we join for a cup of tea in the canteen.